And you could G-chat me if there's any, you know, or just use the chat box. Never mind, there's a chat box here.
Yeah, that's what I told them. Like, please.
Oh, it says live now.
We're live.
Well, there was a very little, okay, so we're live?
Oh. Are we live?
Yes.
Yes,
Greg is live.
Okay, all right. I was gonna flip out like Bill O'Reilly.
Okay, I have no background, so okay.
All right, but you could, this is live, but for the video, you'll cut this awkward whatever introduction out, I'm hoping. Okay. All right. So I'll start, we'll just pretend 1, 2, 3. Welcome to Green Card with Greg. Host attorney Greg Ippolito with Gehi and Associates. We have 3 office locations in Queens. You can see them right here. Today, we will be talking about special immigrant juvenile visas. This is when you have a child, someone below the age of 21 or 18, depending what state you're in, and this child is either abused, abandoned, or neglected by their parents, and the court makes a finding that it is not within the child's best interests to be reunited with their parents. Now, today we have a special guest, Stephanie Luna. Full disclosure, we had offices next to one another when I was working in Jackson Heights. Right now I'm in Ozone Park. And she left me for 𝐿𝐶𝐢 𝐀𝐬𝐬𝐨𝐧, who she works with very closely. Stephanie's been working at the firm for a long time. She is well qualified to answer many questions. It provides answers. She has extensive experience in family court and immigration as well. So I'm going to depose her today and ask her about the family court side of special immigrant juvenile visas. Okay, Stephanie, introduce yourself.
Hi. Yes. My name is Stephanie. I work for the office in Jackson Heights. Like Mr. Attorney Greg said, I do have experience with SIJS for minors for ages 18 or 21, depending on the state.
Okay, so I'm used to the petition we file with on the immigration side is called Form I-360. We've discussed this before with VAWA cases, Asian cases. Just a little background. I could be wrong with it about this, but I believe the form itself started after the Vietnam War, when there were children of US military left behind in Vietnam, and they weren't treated well by the government and they were persecuted. So if they could be brought to the United States or had visas granted, they could then come to the United States and get a green card. Now this form is used for battered spouse, a widower or widow of a US citizen, and it has several other applications. But just, you know, a little bit of knowledge, if you think of these petition forms, you have an I-130, that's when you have a family member sponsoring you. An I-140 is when you have a business sponsoring you. 589 is almost as if the government is sponsoring you because it's an asylum case. And I-360 is a self-petition. You're sponsoring yourself. That's a gross oversimplification, but you get the idea. So once you have a approved petition application, you can then use Form 485, I-485, to apply for a green card. Okay, so the first step is one of these petitions. And today we're talking about the I-360 and special immigrant juveniles. But before you can file this form with USCIS, there's a lot of important stuff that needs to be done. It's a 2-step process. And that's what the lovely Miss Luna will be helping us with today.
Yes, it's a
Okay.
two-step process. Usually we have to submit specific forms to family court. There are actually several forms. They are the 601, 62, 63 forms that get sent out to family court. 63 are for minors ages 13, saying that they are aware that their petition is being filed at family court. 61 are for forms that are saying the minor child and the parent are filing a petition to family court. Once the forms get submitted to the court, it depends on the county that they live in. So for example, if there's a client that lives in Queens, we submit the forms to the Queens Family Court. They live in the Bronx, they also get submitted to the Bronx Family Court. So it depends on where they live. And also if they live in another state, so it usually depends on the state that they live in. For New York, I'm going to speak for New York. Obviously, they have until the age of 21. So for example, if there's a minor that comes to the firm that's like 20, and they want to do a SIJ application that can prove that they've been abandoned by a family member. And I also like to point out that abandonment also includes, for example, if their mother or their father passed away. So that's also included as abandonment. We can show the proof to family court that this child has been abandoned because one or both parents have been deceased. So that's how the family court process is. Once we get a court hearing from family court, these forms get shown to the judge. They also have to be allowed to be fingerprinted to show the child that is mainly to show that the child is in a safe home environment, and that the guardian, it could be anyone, regardless of status. So it could be either one of the parents that's still alive or the parent that's still with them. It could also be an uncle, any guardian that's above 21 that can petition for this minor child. So once that happens, sorry, I'm so nervous. So once this happens,
Don't be nervous. Our offices were next to one another.
I know.
Used to deal with the most, you're calm under pressure. I've seen you.
Okay, I'm sorry. So it could be anyone. It could be an uncle and aunt. It could be a neighbor. We actually have one case where it was just a guardian that, you know, this lady met him in the street, and she was the one that did the petition for the child under the age of 21. So they have one hearing. Once they do the fingerprinting, they do send someone at their house that checks if the child has everything that is required, for example, food, their own space, their own bed, if they have pretty much what a family court will ask, like fire alarm, in case of an emergency, where will the child run to? If there's a case of a fire, hopefully there's no fire. So that will be the family court process. So that's one of the hearings. And then the second hearing, usually if the child is, let's say 13, they do ask them several questions. One of the questions could be, if the kid, let me just rephrase that. If the kid it's like 5 or 6, they usually ask them really simple questions like who takes care of you, who takes you to school. Obviously the child would say, oh, my mom takes care of me, my mom takes me to school. So these are the questions that they ask the minor. If they're 13, they ask them the same thing, but also like, well, what are their plans for the future? Are they still in school? What is their favorite subject? So that's the family court process. It could be from 1 to 2 hearings. If they're lucky, just one hearing where they sum everything up. if everything goes fine with the fingerprinting. And then at the last hearing, the attorney would just show up, and once the judge approved these forms, they are called special orders. Usually the judge or the clerk would email the attorney these forms, and we will begin the process of the I-360.
Okay.
Mhm.
So on the, you said there are forms depending on how old they are.
Yes,
So there's the 6-3 and the 6.
6-1 is pretty much for everybody, saying that we are filing a petition for a minor child. 6-2, it's saying who is going to be the guardian for the child.
Okay.
And then 6-3 is saying that he is a minor child from the age of 13. It could be until the age of, I'm speaking only for New York, maybe 18, 19, 20, saying that he's aware that this issue is being issued at family court, that he is aware that the guardian is going to petition for him until he reaches 21.
Okay.
Mhm.
Does the guardian or does the child need to live with the guardian?
Yes.
Even if they're over 18?
Yes.
Okay, so they have to be living with the guardian.
You have to be living with the guardian. Mhm.
Do they have to know the guardian for an extended period of time, or
No. It could be literally anybody.
okay, that's just willing to help out?
Yes, but cannot have any criminal record. Let's say, let's just say the guardian is their uncle, but the uncle has a criminal history of any sort. Then if he gets fingerprinted and it does show up, it could be an issue. So it could be anybody, but it has to have a clean record and willing to sponsor for that child for the time being.
Okay.
Mhm.
What are the consequences for the guardian?
There are no consequences for the guardian. Let's just say it's a minor child, and let's say the parents, and they have no status. It doesn't affect them whatsoever. Obviously, the only issue that might arise is if they have a criminal record. But other than that, there's no issue.
Okay.
Mhm.
So you take these forms, you submit them.
With the I-360 application.
Okay, but before we even get to that, the family court part, what is like, what testimony is required? What evidence is required? How does the hearing work?
So the hearing, once we submit the forms, they do request, for example, if the minor child was abandoned, they do want proof that the child was abandoned, and it could be several forms. It could be a statement from the minor child saying, my name is so-and-so, my date of birth is so-and-so, I've been abandoned by one or both parents. That's one of the proof. If the minor child had a deceased parent and we are filing for family court, we have to show proof that one or both parents have been deceased. And obviously we have to submit to the court that the death certificate. So those are the several examples to show. And obviously, if the child has been abused by any sort of form, it could be physical, whichever, we have to submit a statement from the minor child. And if he also has photographs of any kind, we can also submit them.
Okay.
Mhm.
So that's the first hearing. The judge just kind of asks,
Yes.
on
Mhm.
what was the abuse, abandonment, or neglect.
Mhm.
Then at the second hearing, they go to the house, they review everything. Second hearing, it's the special findings order is then granted.
Yes, the judge will grant, if everything turns out fine, they will grant the special orders. That's what they're called. I don't know why they call them special orders, but they're called special orders. Yeah, so once we get the special orders and we start the process called the I-360, which has to be submitted to USCIS. Mhm.
Then we have, yes, then it goes to USCIS. So
Mhm.
then I come
Mhm.
in. Okay, so what if there's one parent and the other parent has abandoned them, can they still apply for SIJ under this?
I'm sorry, can you repeat the question?
So if you have one parent
Mm-hmm,
abandon the child,
mm-hmm,
they still are being raised by a mother or a father. They're
mm-hmm,
still raised by one parent.
mm-hmm.
Can they still apply for SIJ?
Yes, they can.
They can. There's no bar on that. Okay.
No, no, it doesn't matter. It has to show, usually with SIJS, it has to show that either one or both parents have been abandoned. It could be mom or dad. It could be the mom that abandoned the child and just the father is raising the child. We can also do that. However, since we're still dealing with family court, that parent that has abandoned the child, we must inform them that we are doing this kind of petition. And it's a must that they have to be informed and we have to serve those papers. So the parent that's doing the petition at family court must inform either the mother or the father that we're doing this petition, and we have to serve these documents. During the family court hearing, the parent that has abandoned the child has to appear for that one hearing, and they're going to ask him, are you aware that this petition is being filed? They do ask them series of questions, but not fully to an extent. Usually they ask mostly the guardian. It could be the mom or dad or the uncle or the aunt. Questions regarding to the child. Obviously, the parent that has abandoned the child, they ask them, are you aware that you are losing your parental rights? And obviously the father or the mother have to say, yes, I am aware. And that is the last time that they're asked any questions towards that father that either has abused or abandoned or neglected that child.
What if the parents are in a foreign country?
It doesn't matter. Family court wants the parents to be served regardless of where they are.
Okay.
And even in, for example, if they can't locate the parent, let's say they're in Venezuela and they don't know, they served these papers and the papers were not reached, family court still wants the other parent to be aware and be given those documents.
Okay. What if you can't find the parents?
Usually what family court does is that they actually send someone to investigate, to see where the parent is. For example, let's just say a father is with the minor child and they're trying to locate the mother, and their last contact was in, let's say, in the Bronx. They actually send someone to search for that parent, and it could be either through a phone number, it could be through media, but they have to inform this information to the other parent.
But if say that there's a child here in the United States, abandoned, 16 years old, their parents are living in Botswana. We can't get a hold of them. We don't know where they are. How does the court deal with it then?
It's a little complicated when, let's say, the child has been abandoned here and we can't reach to them. Usually we ask the guardian, do you have any information from the parents? Do you know where they might be? If they say no, we will try our best. That's when you come in, Greg, to see if you can, help sort of figure out the situation where to locate the parents. And we have to show the proof that we tried to do this, we tried to do that, but nothing could be
to get a hold of them. They've disappeared.
Mm-hmm.
Right. So you get the special findings order, you submit the I-360.
Mm-hmm.
Can you do it with the 485 altogether, or do you have to wait for I-360 approval?
We usually prefer, we can do the whole package together. We can do the I-360, the I-485, it depends. We usually like to wait for the I-360 to come first.
Okay.
And then we do the I-45, but it doesn't really matter at this point. You can just do I-360 and I-45 at the same time, or the work permit, I-765, whichever you prefer. We can submit the whole packet together. And
Yes, the work permit is very important for children.
Mm-hmm.
It's seriously, on that note, we apply for the work permit because it's some form of ID, legal permanent ID. So we're not suggesting that these children should be working. It's more so that there's some form of identification or status in the United States showing something's pending.
Mhm. Yeah, and obviously
Not
once they get their
intense.
work permit, once they get their social, obviously in the future, they
Yes.
can, open a bank account, they can, apply for
Go to
university.
school. Yeah, that's another reason we do the work permits, because it all
Mhm,
goes to school,
mhm,
especially if they're older and they want to go to college, right? They need
Yes.
to form, something besides their birth certificate.
mhm.
Okay. So are there any other for the applicant's family? Can child 21, can they petition for their parents?
No. So one of the things about SIJ is that they cannot petition for their mom or dad, even though they're going to be the guardian until they age out. Unfortunately, they cannot. I guess we're still waiting for a new law in the future. Perhaps, maybe in the future, they're able to petition for their mom and dad once they're a green card holder or a U.S. citizen. But for the time being, no.
Okay. But if they abandon their kid, it's, anyway, this is a policy issue. And
Mhm.
sometimes these cases are tough. It's not as if there's someone, an abused child. There's sometimes people where the parents wish they could have, been in their child's life, and are impoverished, living in a foreign country, and have, for all intents and purposes, they have legally abandoned their child. But that doesn't mean that they're necessarily bad people, right? And so, okay. So after we submit this and poof, it gets approved and you're now a legal permanent resident green card holder?
Yep.
Okay. And then when can you apply to be a citizen?
I guess obviously once they turn 21, we suggest that obviously, and then, obviously we have to wait for the whole process with USCIS until when they're able to qualify to become a citizen. But 5 years. I'm so nervous. But yeah, once it turns 21, they have to wait minimum of 5 years and then they can qualify for US citizenship.
Okay. All right. You'll get a green card. So we submit the I-360 with the special findings order from the court, and or with the 485 and work permit application, which is with the Social Security. And then is there ever an interview?
Sometimes. So it varies. Yes. I think that's why we prefer to submit the I-360, the work permit, the I-765, wait for that to get approved. And then, once we get the I-360, we submit I-360 with the I-485. And then between that time, sometimes they do ask the minor for an interview. So, but sometimes there are cases when they're lucky, they have no interview. So it varies.
Yeah. Okay. So Stephanie, what other, talk about yourself a little. What disciplines do you work in at Gehi and Associates?
Do I have to comment?
Anyway, if you want to move to the Ozone Park office, we can arrange that as well.
I will have to move first.
Okay. All right. Anyway, thank you for watching. This is not be considered legal advice. It's attorney advertising. We have 3 locations. You can find me at Ozone Park. The address and phone number are on the, wherever it is. Stephanie is at the Jackson Heights office. And we also have an office in Jamaica where Mr. Gehi, the lead attorney, 𝐀𝐞𝐢 Associates is. But you could come in, we do free consultations. You'd speak to any one of us. We'll have coffee, tea, water. We'll discuss your case. And we'd like to see you.
And we're open 7 days.
7 days. Her office is open 7 days. My office is closed on Sundays. But her office is open 7 days. We're only Monday through Saturday in Ozone Park.
Mhm.
Well, thank you. So if you want to have a SIJ case, or you know someone that you would like to, an immigrant child who you'd like to help, come in Jackson Heights. You can come in any office you want, but if you go into the Jackson Heights office, you'll meet Stephanie and 𝗙𝗪𝗓𝗪𝗪𝗪𝗪𝗪𝗪𝗪😂 They are extremely professional. They do these all the time. They will answer any of your questions regarding SIJ. I can also help you too if you're in the Ozone Park neighborhood. Thank you very much for anything. Do we have any questions before we leave?
I think there is one. It says, can I work or I guess attend school if I have SIJ? The answer is yes. You can apply, you can go to school. Meanwhile, your SIJ is still pending. Can you work? Obviously, it varies from state to state. I think if I'm correct, 16 is the age for you to legally start working. So
I'm not giving any breaking any child labor laws here.
Yeah, but it depends
go to
on
school.
But it's just for them to go to school. Yeah, school they can go. If I
Is SIJ relief permanent? Yes, SIJ relief is permanent. Okay. With SIJ relief, can I travel outside of the United States? Yes.
Once you get once you get the permanent resident, yes, they can travel. But meanwhile, they don't have the green card, no. With the work permit, no, they cannot travel.
Yeah. Okay. Okay. Does the guardian have to be related to the child? We just discussed, no, does not have to be related. They can be, but they don't have to be. So, but on that note, if you're single parent, are you then the guardian of that child?
Pretty much, yes. But we have to show the court
that the other parent abandoned them.
Let's just say the other parent abused them. Let's just say he was being beat every day, or he was not being fed every day, or, well, we don't know. It could be for a ton of reasons. We have to show the court, like, this is the parent, she's going to be the permanent guardian, but she's also the mother of this child. And for that, we have to show the birth certificate, which is really important for the minor child, to show that he's still a minor child for the petitioner family court. And obviously they will ask an affidavit from the parent as well. Are there, but so say the child gets their SIJ case approved, then they turn 21. In that case, are they allowed to petition for their guardian? No.
Still no.
No.
Okay. So the guardian parent would have to find other relief.
Yes, for the parent, yes.
But that also means you don't need any immigration status to be the guardian.
No, it's not required.
So you could have no status in the United States and still be the guardian.
Still be the guardian.
We see this a lot. People, they're especially New York City and Queens, many immigrant communities, and people take care of it, like to take care of each other. We deal with a lot of horror stories here, but we deal with a lot of we see overwhelming acts of kindness. And a lot of communities, if there's an abandoned child, they will take care of them.
Yes.
Okay, so anything else you would like to add, Stephanie? Talk about work, gossip.
Work is stressful.
Work is, but you do such a good job, Stephanie.
I try.
Miss Luna, right? So please come to Gehi and Associates. We're here to help. And thank you for joining us, Stephanie. It was a pleasure having you on Green Card Greg. Hope you're watching, and we'll see everyone next week. Okay?
Okay. Bye.
Bye.